Buenos días a todos.
Good morning to you all. Welcome again to this doctoral seminar on the European projects, modernization and governance in a plural framework with shared values and goals. We are almost at the end of the seminar, but there are two participations left. The first one will be by Ruth Polak from the University of Salamanca. She's very international. She was born in the United Kingdom, but she's grown up in the south of Spain, and now she's in the University of Salamanca, a university with which we have excellent relations. She's going to speak about a very current pressing issue, the issue of Brexit, Article 50 of the Treaty of the European Union. We have as moderator one of the members of the jury, Professor Teresa Freixas, is professor of Constitutional Law at the Autonomous University of Barcelona and Jean Chair ad personam. Her professional activity has passed through the university and as a legal expert of the European Commission and the European Parliament, where she has participated in the elaboration of the Amsterdam Treaty, the Charter of Fundamental Rights, the European Constitution, or the project of European Constitution, and the Lisbon Treaty, as well as in the Council of Europe, where she has participated in the program of juridical assistance for the East European countries to form magistrates and professors and supervise the legislative adaptation process. She's Secretary General of the Royal European Academy of Doctors, former senior expert of FRANET, Fundamental Rights Agency, and European Institute for Gender Equality Legal Experts Group, and main researcher in several projects of research and development, European programs, and high-level working groups. She's been visiting professor in different universities in Europe and America, and member of several scientific committees and observatories. She has published many books, and she is intensely participating in dissemination in the media and in social media on issues that we're not going to refer here to, but that are very concerning for us, but always with that rigor and seriousness with the rule of law and the application of that framework. She has participated in many of the summer courses here. For us, it is an honor that you have accepted to be a member of the jury of the Charles V Awards, scholarships, and that you have agreed to come here. We are very honored to have you around. Thank you, and you have the floor.
Muchas gracias, Miguel Ángel. El honor es mío.
The honor is all mine. Thank you, Miguel Ángel, to be here in this beautiful site with all the professionals, the friends, the researchers. I really thank you very much, because this allows us to see things from a different perspectives, because you can check them with people coming from different places, from different cultural backgrounds, scientific approaches, and even personal values. That is very enriching. The truth is, tackling the topic that Polak has chosen is quite complicated. She's going to do it as she has presented in her paper, rigorously and touching upon the main important points. I wish to highlight, to present it, not what she focuses the most on, but something that has preoccupied me since the Brexit debate was initiated, and this is the fact that the Article 50 refers to the fact that agreements for countries that wish to leave has to be done following their constitutional system. It cannot be done in any form. political will is not enough. The decision has to follow the procedures that its own constitution of the state marks. Some say, well, but the United Kingdom has no constitution. Yes, it has a constitution. Very special because it is open and flexible, but it has a constitution. It has the Parliament Acts. It has the constitutional conventions, which are very important for the Brexit, because as sometimes has been proved, these conventions or other constitutionally valued agreements in the Parliament are the ones that have marked the debate, traditions, the decisions of the judges with a constitutional value. This marks the procedures that have to be followed, which is different from other countries, because in the United Kingdom, sovereignty resides in the Parliament. It's not popular, it's not the government, and the government of the United Kingdom should understand, because it seems that it has not wished to understand it, that sovereignty falls into the Parliament. And the last word about Brexit is going to come from the Parliament, as some tribunals have already signaled. That is why it's so difficult to make the decisions. It is very important because this is an important precedent for the EU. Article 50 allows a state that has joined can leave. I don't know if this was a good idea to include this article. I remember the debate when it was included, and I thought it was not that appropriate to include it, because signaling the procedure that is provided for in the article leads to a withdrawal, which is very difficult to carry out. Following the whole procedure is so difficult that they don't know how to do it. How many commissions of legislative study about which way legislation will have to adapt to Brexit in the United Kingdom have been dissolved? Every time they have appointed one, it has stopped functioning because they don't get to withdraw, because European integration, although we are probably not so much aware of it, what has been related to legal integration, to be able to withdraw from those norms so that one can decide what prevails of the old law, when the union law is not applicable, when many directives have been already included in domestic legislation, when policies have been decided following the European framework. How do you separate and divide that? I think the union was made for deepening the union, not to open the door for withdrawals. Of course, in view of the democratic principle, it was left that open door, but that democratic principle, look what has provoked in the United Kingdom, which Polly will explain to us right now. Not only at political level, which for me sometimes politicians, well, they may decide what they want, but what is going to be the social and economic impact in the UK, and as a precedent, whatever is done there, what can derive from there if other countries also wish to apply Article 50. I leave the floor to Ruth Polak, who, as Miguel Angel has explained very well, has a very European background, born in the UK. She's grown up in Spain. She has studied in several places, and that is what is characterizing us, generally speaking, the enlightened minority, if I may use the term, because unfortunately we haven't achieved the fact that the citizenry in general can follow more closely all these. Polly.
Thank you very much, Teresa. The first thing I must say is that it's a privilege for me entirely to do my presentation on Article 50 in front of a person who was actually there when the treaty establishing the Constitution for Europe was being debated and written, and Article 50 was being inserted in EU primary law. I must also, of course, thank the Foundation, Don Marcelino Oreja, for giving me this wonderful opportunity. I would also like to say that I'm very happy and proud to be here. I think that is shown in the fact that I invited my parents to come. Well done to all my other colleagues who have done an excellent job, and they have given us some very interesting food for thought, and I hope my presentation will also be interesting. It's been said here, I'm a PhD researcher in EU law at the University of Salamanca, and my thesis, the aim of my thesis, what I am seeking to establish is a comprehensive legal regime of the right or of withdrawal of a member state from the European Union. Of course, enshrined in Article 50, but taking advantage of the first and unprecedented application of this provision, namely the Brexit process. The paper that I'm writing in the framework of the Carlos V European Award, which I will be presenting today, deals with one of the first questions that I sought to answer concerning this legal regime of withdrawal from the European Union. As my title reveals, that question is about the right of the member state to withdraw, and more specifically, what is the quality of this right, whether it is unrestricted. Sometimes I use the word unfettered, unrestricted. It basically means the same thing. What I mean by is the right to withdraw unrestricted is mainly two things. Whether a member state can unconditionally withdraw from the European Union, meaning does it need to comply with any conditions, or is it absolutely free to withdraw without any requirements, without justifying its actions in any way? And secondly, by unrestricted, I mean, is a member state's right to withdraw from the European Union unilateral, which means that it does not need the consent of any other member states inside the EU, that it is a unilateral decision of the state that wishes to leave. So I want to start with a brief introduction to sort of the international relations among states, which is going to give us the bigger picture in which this question is inserted. This has also been mentioned quite a lot, so I'm happy to make these statements that seem relevant to this seminar. The world today is still primarily organized in a state-centric manner, meaning the states are still the main configuration in which people have decided to organize themselves, and this means that the state is still the main international actor. However, since the beginning of the 20th century, there are many functions of the state that are its basic functions, such as preserving national security or economic prosperity. And these functions don't seem to be exercisable any longer in an isolated manner. Awareness of this so-called increasing interdependence of states to ensure, firstly, peace, but without which no other sort of aim of a state can be achieved. Awareness of this among statesmen especially grew after the Second World War. And this caused international cooperation, as probably everyone here knows, to proliferate in order to avoid war, but also to cope with a growing list of other transboundary problems. So today, most states do not decide independently in isolation. But on the contrary, there are countless instruments of interstate connections that can range from simple diplomatic or more casual relations to legally binding international treaties and, of course, full-blown international organizations, one of which we are here to talk about. So what I have put here is a quote by Douglas Hurd. Douglas Hurd was Margaret Thatcher's foreign secretary, and he gave a speech in London in 1992, which I think is very illustrative of this new belief in the need to cooperate, state cooperation. What he was doing with this speech, in fact, was to try and repair relationships that had been damaged by Margaret Thatcher's increasingly Eurosceptic tone that she used in her later years. He said in 1992, "It is against our fundamental interest to isolate ourselves from the continent of Europe, so that policies are organized there, but which deeply affect our security or our prosperity, but in which we have no important say." He was referring to the possibility of the UK not belonging anymore to the European communities. This is during the ratification of the Maastricht Treaty. And he said, if that were to happen, we could keep our sovereignty as a slogan, but its substance would have gone. What I think that this illustrates is an underlying fundamental tension in this new state cooperation, because on the one hand, we have an inherent wish of the states to remain sovereign and independent. In this example, that would be represented by Thatcher's Euroscepticism. But on the other hand, we have a conscience by her foreign secretary that 21st century globalization no longer allows the state to remain unaffected by decisions taken in other parts of the world. So you either decide with other states or you have decisions taken for you. Today, of course, this tension, this underlying sort of struggle between the two phenomena is very existent still today, and I think the most relevant expression and the centerpiece of my research of this struggle between the wish to be independent, to be sovereign, and the need for cooperation is represented by the withdrawal process initiated by the United Kingdom. Why is Brexit such a good illustration of this? Because, as everybody here knows, the treaties establishing the European Union impose stronger constraints on a state's powers than any other international treaty in the world. And of course, Brexit is the most severest result of the wish of a state to remain or recover its sovereignty by removing itself from under those unparalleled restrictions that the treaties on the EU place on its powers. Everybody here is aware of the fantastically efficient slogan of the Brexit campaign, "Take back control." Sorry, I need to drink some water. So, one way that a state might try to prove, in fact, that it is sovereign and it is independent and it is in control, one way that it might boast this fact, because it wants to prove that it is in front of the world, it wants to prove it to itself, is to consider that even if it is bound by a network of international commitments, that in fact it can unilaterally and unconditionally remove itself from them at any moment. So this would mean that it still remains ultimately sovereign. But can it really? Can a state do that? Can it walk away without any conditions, without any consent from the other parties to the treaties? Well, Don Marcelino, in his opening speech, mentioned the school of Salamanca, la Escuela de Salamanca, and how already then, hundreds of years ago, it began to be theorized the need for limiting state power through a law of nations. Today, under public international law, fortunately, the general rule is that a state cannot unilaterally and unconditionally remove itself from any international agreement. The general rule is, in fact, that a state, once it has entered an international contract, it has to perform it in good faith. And it can only renege on its commitments, either with the consent of the remaining parties, meaning the right to leave it is not unilateral, it needs the consent of the remaining parties. If it doesn't have the consent, it might be able to remove itself under very strict conditions. So no, it is not an unconditional right either. This is the famous pacta sunt servanda principle. I'm explaining it here because not everybody has a legal background, in very simple terms. However, under EU law, as everybody knows, Teresa better than anyone, since the Lisbon Treaty in 2009, the European Union has been equipped, or as some authors like to say, ill-equipped, with its own withdrawal clause, which is, of course, a lex specialis, and it overrides that general rule. So we have to go to the famous, now very famous Article 50 to see how we can understand this right to withdraw in terms of EU law. And this first sentence, which was also mentioned by Teresa, any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. And this is the big pillar on which well, I don't know how big a part of the doctrine, but an important part considers that the right to withdraw from the EU is completely unconditional and unilateral. My aim today is, in fact, to argue on the contrary that a member state does not have an unrestricted right to withdraw. So I found many explanations to uphold this view. Nonetheless, of course, today I will only be using some of the main arguments because of time constraints. The basis of all of the arguments that I will be using is what I believe is a correct interpretation of Article 50. So as I said, part of the doctrine considers its own constitutional requirements and other parts of the article that we will see further on as proof that it is a unilateral and unconditional right. However, I believe that if we look a bit closer and interpret Article 50, which I am doing under the interpretive guidelines offered to us by public international law, because the EU treaties are international treaties, and therefore they have to be understood or interpreted. I'm using the very basic principles of the Vienna Convention again, which, as we know, is the set of rules by which state relations through international treaties are established. And I know the Court of Justice has its own sort of interpretive guidelines also, but I thought for this presentation it would be more simple. So the Vienna Convention tells us that when we interpret a treaty or an article, we must do it in accordance with the ordinary meaning to be given to the terms of the treaty. So, okay, we look at the terms, but we don't just leave it there. We do that in their context and in the light of its object and purpose. So we have to take into account Article 50 inside the legal system that it pertains to. And Article 31 of the Vienna Convention also tells us that when we interpret a provision or a treaty, together with the context, we take into account any subsequent practice in the application. So this is why Brexit is so important, because it is establishing a precedent, as Teresa said also, on how we are going to interpret the withdrawal clause in the future, because as the Vienna Convention tells us, Article 50 must take into account this subsequent state practice. So, I'm going to be interpreting Article 50 in these two blocks. A first block will be understanding Article 50 in legal context, as Article 31 of the Vienna Convention tells us to do. The context that it belongs to are the treaties, their object and purpose, and then the second block will take into account the subsequent practice, which of course refers to Brexit. From the first, what I hope to conclude, which I can advance here, is in fact the right to withdraw is not unrestricted. And from the second, what are those restrictions? if I'm saying that it's not unrestricted, then it means there are restrictions. What are they, or what has Brexit shown us that may be those restrictions to withdraw? The legal context to which Article 50 belongs to are the treaties. What are the purpose of the treaties? This has also been debated here. Our German friend, who unfortunately isn't here with us today, at some point mentioned, who knows where we're going, maybe if we knew, that would be helpful for the European project. But what we do know is that from the very beginning of integration, one of the main aims, if not the main aim, has been inserted into the treaties as creating an ever closer union among the peoples of Europe. This is a very important element that is taken into account with many others, which I can't explain all of them here, but which you're familiar with: direct effect, citizens' rights, things that separate the European Union from ordinary international organizations, which make it what we might call a supranational organization, although this is a very debated concept as well, but we can say sui generis, something that is different from just ordinary international organizations. Many of you here are also familiar with the European Court of Justice's early case law that characterized the EU treaties as the basic constitutional charter of the then communities. These are all sort of elements that are telling us where Article 50 is inserted. It isn't just an ordinary treaty. It even is considered by the Court of Justice as the constitutional, or the constitution of the EU. Maybe less known is the Court of Justice's ruling in Levert's case in the 80s, where it literally stated that the transfer by the states of powers from their domestic legal systems to the community carried with it a permanent limitation of their sovereignty. Does this hold still today under the Treaty of Lisbon? Well, under this vision, and including also the very mentioned in this area when we're talking about withdrawal, the fact that the treaty also states that it is signed for an unlimited duration, these are all elements that one might conclude from that the EU has in fact a constitutional nature, and that this constitutional nature might be incompatible with a right to withdraw, a bit like the secession of a part of a territory of a country normally isn't allowed under a national constitution. So that would be a sort of very constitutional vision of the EU. I don't agree with this so advanced view of the Union, which assimilates it more to a state than an international organization. I don't think the right to withdraw is, of course, forbidden. Especially after Article 50 has been introduced. But nonetheless, the EU does contain all these sort of constitutionalizing factors just mentioned, and undoubtedly represents the most far-reaching and most advanced international organization in the world. So this also has to be taken into account when we talk about Article 50 in legal context. It seems to me that it is against the nature of the EU, its purpose, its object, to understand that withdrawal is entirely unrestricted, because this would in fact mean that withdrawal from the EU can be exercised in easier terms than under general public international law, which, as we saw, is founded on the basis of the principle of pacta sunt servanda. And the general rule in international law is that you need the consent of the remaining parties, or you need to comply with some very exceptional conditions. So I don't believe that it can be easier to leave the EU if we look at Article 50 in its legal context. So as I say, I don't believe it's forbidden, but I don't believe either that it's unrestricted, and this is what I've called sort of a middle way doctrine, is to understand Article 50 in light of the EU's special legal nature as restricting, so not forbidding or allowing unrestrictedly, but as restricting the state's capacity to walk out unilaterally and unconditionally. So now we're going to go to the second part. I'm doing pretty well with time, I think, where we are going to search for those restrictions in state practice. So we're going to look at state practice also. because this is what a correct interpretation of Article 50 requires. This is the final part of the presentation. What happens when we apply Article 50 for the first time ever? Well, what has happened is that, in my view, and there are obviously doctrine that I cite in the article and who also share some of these views, what has happened is that certain fundamental elements of the Union have played a significant role in restricting the United Kingdom's right to withdraw. Firstly, by requiring the respect of the Union's fundamental values. I believe this is a condition for withdrawal. And secondly, by the principle of loyal cooperation, very cited in the doctrine that is emerging now around withdrawal, has restricted the unilateral character of this right. We're going to start with the first one, the fundamental values of the EU, which everybody here must be very acquainted with because it is the subject that Don Marcelino chose. Enshrined in Article 2, I believe these fundamental values must necessarily constrain the decision of a member state to withdraw from the EU. If we return to the text of Article 50, which I put up before, which has already been mentioned, as I said, it's paragraph 1 states any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. I hope I'm not going too fast, sorry. This is the basic pillar, as I say, which part of the doctrine, which doesn't agree with me, and I don't agree with them, believes that withdrawal is unconditional, because they say that its own constitutional requirements means that it is clearly recognized in the EU law that the EU cannot require any conditions. They can only be required by the state itself internally, and the state decides what those conditions are and whether it has complied with them. So it would be unconditional from the point of view of the EU because the state decides what its conditions are and if they have been complied with. This would be absolute autonomy for the member state. I don't, of course, agree with this perception, because actually when you decide to withdraw, what you do is, this is inserted into Article 50, paragraphs 2 and 3, what you have to do is you send a notification of intention to withdraw to the European Council. And when the European Council receives the notification, it activates the famous 2-year negotiating period. So my question is, if the European Council needs to acknowledge receipt of the notification of withdrawal for Article 50 to be effectively triggered and for the 2-year negotiating period to start, what happens if it doesn't believe the constitutional requirements of the state satisfied are in line with the Union's fundamental values, such as the rule of law and the principle of democracy, which would be the very important one here. As Teresa said, you need, in UK, for example, it is a parliamentary sovereignty. So what happens if the government decides, yeah, that's where I'm going. We'll look at the practice a bit later. Can the European Council accept a notification that it doesn't believe is in line with the constitutional values of the EU, not just the states? Can it refuse to activate Article 50 in this case? What I'm fundamentally asking is withdrawal, in fact, conditional, and not unconditional, conditional upon compliance with the state's own constitutional values, but also upon acceptance by the EU that its fundamental values have also been respected. So we go to the case of the United Kingdom. What can we learn from it? Also pointed out, it's a very interesting case because it doesn't have a written constitution. So what are the UK's own constitutional requirements to leave the EU? Normally, the Constitution, Spanish Constitution, has an article which tells the state what the process is to both join the EU and also leave. In the UK, no such thing. This has never happened before. This is why we arrive at the very interesting and probably well-known case of Miller, UK Supreme Court. was asked what these constitutional requirements were for withdrawal to activate Article 50. The Supreme Court rejected, firstly, the idea, not so directly, but if you go into it and you read, it suggests that the UK should not notify its intention of withdrawal without having held a referendum first, or, for example, if the referendum result had been negative. So the Supreme Court thought that in such a case, the government wouldn't be justified in activating its withdrawal. It went a step further. It said that in case of having a referendum in favour, this wasn't sufficient for the government to activate Article 50. As everybody knows, it was also required that the government gain authorization by the Parliament. It gained both, and therefore it activated Article 50, and I believe, therefore, that firstly, that there were very strong constitutional requirements required and also complied with by the United Kingdom, and in my opinion, the European Council accepted correctly the notification and activated correctly Article 50. But what I am contending is that if the UK government had notified the European Council, for example, before the judgment had been settled, so ignoring that there was this case in the Supreme Court, or against the judgment without, for example, authorization by the Parliament, then the EU would not have been able to accept that notification. And the process would not have been triggered until the question of validity of the notification remained. So therefore I am concluding is that it is incorrect to consider that the EU treaties recognize an unconditional right of the member state to withdraw, because in fact, in order to initiate the process, the withdrawing member state must comply with the EU's fundamental values. Finally, we go to the second restrictive element in the EU in order for a member state to withdraw. Once the decision has been lawfully taken under the UK's own constitutional requirements, as just explained, and the 2-year period has been triggered, the next and last question I want to ask is whether the member state, as I say, can also leave unilaterally. So does it need to reach a deal or at least consensus with the remaining parties? If they oppose its withdrawal, what happens then? Can the member state unilaterally depart? This, in the practice, in the Brexit process, means, as some believe, that the UK activates Article 50, as it did on the 29th of March 2017. Okay, withdrawal is not immediate. It has to wait for those 2 years. But could it just sit on its hands and not do anything more and just wait for the 2-year period to expire, and then withdrawal becomes effective? Is this possible? So I don't think it could. And the reason why is the principle of law cooperation. So during this 2-year period, when it activates Article 50, the withdrawing member state continues to be a member state, which means it is entirely bound by the treaties of the EU during the 2-year negotiating period, and particularly by the principle of law cooperation inserted into the treaties. Why is this principle important? Some of you probably know, I don't know if the majority, all of you, that the principle of law cooperation is widely understood in academia as an enhanced or stronger version, as it were, of pacta sunt servanda, which we have already talked about. It is stronger, it implies deeper obligations for the members of the EU than what generally binds a party to other ordinary international treaties. So what is especially, it's Article 4.3, where the principle of cooperation is enshrined in the treaties, is longer than this, but I think this is the most important or most relevant part to the withdrawal process. This part states, the principle, pursuant to the principle of sincere cooperation, the member state shall facilitate the achievement of the union's tasks and refrain from any measure which could jeopardize the attainment of the union's objectives. So if we go back to Article 50, we will see that the union shall negotiate and conclude an agreement with that state, referring to the one that has notified its intention of withdrawal. The union shall negotiate. This is a direct command. The European institutions have an obligation to negotiate and conclude an agreement. So what is argued by others, apart from me, is that if the member state, which during the 2-year negotiating period the UK still is, and it still is afterwards because they've extended, shall obligation facilitate the achievement of the union's tasks, and the task of the European Union is to negotiate and conclude an agreement, it seems to me that we could conclude that the withdrawing member state is at least under an obligation of conduct, an obligation to negotiate in good faith its potential exit during at least the 2-year negotiating period. And it is only after this 2-year negotiating period of negotiating in good faith its exit. Failing that, it says, paragraph 3, it's only failing the entry of force of the withdrawal agreement because they haven't reached an agreement, so there's an obligation of conduct but not of result. Failing the entry into force of the withdrawal agreement, only then can the state, in fact, unilaterally withdraw from the EU. So it is a unilateral right, but it is kind of restricted to an obligation of conduct, firstly. I'm quite happy to say that this interpretation of Article 50 is very indirectly recognized by the Spanish Advocate General in the Whitman case. If you read his entire opinion with the footnotes included, you can find a little footnote by the Spanish Advocate General suggesting that this could be one interpretation of Article 50. So it's there in the institutional field also. So if we go back to state practice, what does this imply? Well, I think what it proves is that, firstly, Theresa May's famous threat of no deal is better than a bad deal, was in fact empty, not only politically and economically, because leaving without a deal isn't a very good idea, but actually also it was an empty threat legally, because I think that it would have been unlawful for the UK to have walked away from the negotiating tables, at least during the 2-year negotiating period. This principle is also acknowledged in almost all negotiating documents, both by the side of the UK and by the side of the EU. So the letter that Theresa May sent to Donald Tusk activating Article 50, and obviously in all the guidelines approved by the European Council, it has been a very important principle. It's always been mentioned by both sides. I think it has now consolidated itself as a fundamental guiding principle of the withdrawal process, as this is, as we say, establishing a precedent for future withdrawals. Also, although it's already been mentioned also that this might have been a good vaccine against future withdrawals. So my conclusions are, firstly, my opinion that the EU is in fact, the withdrawal from the EU is in fact conditional upon, as I say, the member states' decision to withdraw complying with the Union's fundamental values and not only its own constitutional requirements. And secondly, that the negotiations be carried out in good faith towards reaching a consensual departure, and only if this fails, then the state is free to leave unilaterally without a deal. So I'm going to conclude now well into time, because I was scared of not, because everybody's been so sort of rushing that I've been cutting out lots of information, and now it's a bit short. But I'm going to conclude by recalling the main theme of this presentation, the brief introduction that I started with, and how the European Union is an extreme form of this tension that I spoke about between the nation state's inherent wish to conserve its independence and the modern era's growing interdependency and need for international cooperation. So the European Union is in fact a very extreme, the most, I think, in the world, reflection of this struggle, and of course Brexit is the result. I also think Brexit is a dramatic commentary on the sustainability of the European project. So there are two ways that we can understand the EU. I mean, there are many, of course, but two very basic, simple ways that we might be able to understand the European project. We can see it either as an unprecedented international experiment that requires very deep cooperation, it is true, but it is also in exchange for much more effectiveness, tackling matters of common interest. This is how I see it. Or we can see it as nothing more than an intergovernmental organization in which its fundamental values and the principle of pacta sunt servanda and law cooperation are in fact subordinated to the domestic whims of the sovereign state. I hope to have convincingly argued that this unprecedented application of Article 50 has induced a self-reflection process in the EU, and withdrawal has been correctly interpreted by the institutions in an integrationist spirit of the treaties. The right to withdraw has not been understood as a sovereign-oriented, unrestricted right of the member state. On the contrary, it has been considered imperative during the Brexit process to protect the rule of law, to protect the democratic foundations of the Union, to uphold the binding force of international law in general, the principle of pacta sunt servanda, but also to continue recognizing the special nature of the EU, which is unparalleled in the world, and therefore withdrawal from it cannot be as it would be from any other international organization. In my mind, this is the only correct interpretation of Article 50, as it is the only one that allows us to continue defending the European construct, as I say, as something more than the sum of its parts. This defense has been proven both during Britain's withdrawal, but also I hope it will continue, more importantly, after Brexit, provided the UK does finally leave. Thank you.
Gracias, Poli, por la presentación, por ajustarte al tiempo.
Thank you, Polly, for your presentation and for having kept to the time allotted, leaving us a bit of leeway, which is good in this closing day. In order to start the debate, 2 years ago in Rome, we commemorated the 60th anniversary of the treaty that initiated what today are the European communities and now the European Union. There are people here with whom we met there in Rome. The motto was not to nationalism, not to populism, the two axes that we see in Brexit. Nationalism on the one hand, to wish to leave something that limits the so-called sovereignty, because calling about sovereignty today is quite complicated. And on the other hand, populism of the whole debate that led to the Brexit referendum, Cameron, Johnson, Farage. They did an incredible campaign. All the launching of fake news led to a decision that has led us to something that probably the convener of the referendum didn't want. He took the risk and he failed. You are right in seeing whether there's an unlimited right to leave, to withdraw as they like. We have seen that according to procedures, there are some constraints. And even in the High Court decisions that are already there in the United Kingdom, those decisions mark clear limits. It is not that clear about contents. What is going to be left afterwards? Can we establish any kind of limits? And then the Brexit negotiators. I worked with Barnier and Vitorino in the old days. Barnier is a very strict person. In anything he takes into his hands. Do you think negotiators have used in a correct manner the possibilities given to them in their functions? Have they gone beyond those competences? Have they defended the European interest in a duly and appropriate manner? Because of the precedent that Brexit is going to mean, if this would proliferate, goodbye to the Union. This is a very complicated scenario, which is necessary to analyze in depth and to place in its just point, so that if the withdrawal of a member state happens, if it happens, I believe they are not going to leave. I don't think they're going to withdraw. I've been more than 2 years winning dinners in my bets, because each obstacle I bet my dinner I'm going to turn into teas instead of dinners, because otherwise I'm going to have to renovate my wardrobe. When one is inside, and they were not in reinforced cooperation, they were not in Schengen or in the Euro, because if they had been there, that would have been totally terrible. But we could also face states within reinforced cooperations where elections are won by anti-European Union parties, and we would be, in the face of what happens even with those reinforced cooperations, the Euro and Schengen. So the role of negotiators is very important. How do you see it? Thank you for your comment. About the limits to the contents is very interesting. I think I could include it, or at least take it into account in my research. If I arrive at the agreement of the withdrawal. But I'm very interested in the topic because I have always liked the approach of the citizens' human rights, or rather citizens' rights. Barnier was a redliner of the EU. There are family rights that might be taken to the European Tribunal of Human Rights. It is quite interesting because the design of the content has been done ad hoc. They have decided on, while they were thinking, it limits negotiators, but I had never thought about the negotiators, but it's quite interesting what you say. Of course, they have a mandate of the guidelines from the European Council. I'm speaking like Llanitos in a mixed language code switching. I'm mixing Spanish with English. we have, I mean, they have a mandate. So there's a great freedom. The rest of the states are seeing that this seems like bilateral negotiations. And of course, the withdrawal treaty will be an international treaty about the protection of the interest of the European Union. I can't see very well what it is, because I think that the interest of the EU is that they don't leave, that they stay. So I don't know if there are any other comments or questions. Marcelino Oreja has the floor. I was recalling a class of Bernard Shaw. I can avoid everything but temptation, he used to say. And I have the temptation, after this beautiful presentation, to tell you as briefly as possible a story that perhaps is not known, which is the possibility of having reached an agreement between Britain and Spain on Gibraltar. It is a topic that has not come to the surface that often. Gibraltar has been a constant in Spain since 1713, and interpretation to Article 10 about the city, the castle, the port, and the defenses, with no territorial communications with the territorial neighborhood. I remember that when I prepared my exams. And of course, there is a situation which is totally new. There is a minister who was Castilian, who did a lot regarding Gibraltar. He had me as an assistant Castilla for 10 years. And then there have been some circumstances that I have seen from far away, not as a diplomat or as a politician, but simply as a spectator, but which I have, of which I have a lot of information of what happened in 1998. 98, which tells us a lot from the literary point of view. But from the political point of view, it was a moment when a negotiation was opened for Gibraltar between Spain and the UK. Piqué was the Minister for Foreign Affairs of Spain, and he negotiated with the Secretary of the Foreign Office. And a lot was advanced. It was so much what was done that it was just on the brink of getting to an agreement. There were a few pending issues, and the Secretary of the Foreign Office went to the Parliament in a stormy session where he was insulted for having reached so far. There was a change in the government, came of a change of minister. Ana Palacio instead of Piqué in Spain. The Secretary of State was the same, Ramón de Miguel, here in Spain, I mean. And every year in summer, Ramón de Miguel and the Secretary of State of Britain, they meet in the south of Spain, and I take a coffee with them, and I listen to their sorrows for having not reached the agreement. There's a curious thing here. The formula was more or less that they reached an agreement between Britain and Spain on Gibraltar for a period of 50 years. And the problem was whether after 50 years a referendum had to be convened, or simply it would be given back to Spain. Everything seemed in order, but when the minister changed, Ana Palacio said that she wanted to deepen the topic, meaning sideline it and leave it for good. I didn't understand why. Nobody has explained this to me. It's strange, but it's interesting to know that this happened. It hasn't filtered to the media. So there was a moment when it was feasible. 50 years period is a long period. However, that broke. The truth is that the chiefs of governments have difficulties. I reached an agreement, not so important, of course, on Gibraltar when I was a Minister for Foreign Affairs, and we agreed to sign a text on occasion of a meeting of the Council of Europe in Lisbon. I remember that when I arrived in Lisbon, I was told that the president of the government, who was different from the other one, in this case was Adolfo Suarez, he phoned me and he said, I had already passed the agreement through all the parliamentary steps in the plenary of the Parliament and the Senate, and he phoned me and he said, look, you shouldn't sign it. It had all the bells and whistles, and I would like to go back to the hotel and see the telephone from which I called, and I said, is it firm, your position? It is firm, because I'm going to resign tomorrow morning. These things sometimes have to be used. And I said, since you are very stubborn, go ahead. But what I was interested, this is anecdotal, but what is not anecdotal is what happened before. What happened? I don't know. But it could have been a good agreement for both sides, and Brexit would have probably happened, but not as a consequence of this, because a 50-year period of transition was a long enough period. This is simply for your illustration.
Tema de Gibraltar. Otros temas importantes podrían ser el tema de Escocia y de Irlanda, porque, claro, esto pues, les va a afectar no solo a la integridad territorial, que podría ser, porque, a ver, no sabremos, Escocia es mucho más en general pro Unión Europea que una parte del Reino Unido. El tema de la frontera de Irlanda es súper complicado también en este caso. Pero no solamente por ello. ¿Qué pasa con el petróleo del Mar del Norte? ¿Qué pasa con la flota atómica, que está situada también en el norte? ¿Eso cómo incide en el eje transatlántico? Es decir, hay unas complicaciones en cuanto al contenido del Brexit tremendas en estas cuestiones. No sé, querría introducir Rosa después.
Gracias. Bueno, en primer lugar, agradecer a la ponente porque ha hecho una...
Thank you to Pauli for her presentation, which has been very concise and very clear. She is hesitating about what is going to happen, and we are all hesitating here. So this research has to include these alternatives. I will take the initial argument by Teresa. It's a privilege for her to have her here, and we should make the most of her presence. In her presentation of the paper, she has said, and this is the crux of the matter, why Article 50 was drafted the way it is. As it was drafted, it has led us to the position where we are. We weren't capable of foreseeing it. Perhaps in the drafting process, which is very complicated when one is working in international treaties, you shouldn't leave any loose ends for potential readers of the articles. That is a very complex procedure. But if the problem is there, and this is a suggestion, that Article 50 was drafted in a context and due to a particular moment, perhaps the key, in view of the difficulties entailed by its application, would be to revise Article 50, amending it, of course, with the consensus from all member states. Perhaps it would be easier to go to the origin of the problem than to seek for solutions on the side of the member states to facilitate them different positions. This is simply, a mere, I'm simply reflecting aloud. But the future is really more complex. How do you see it, Pauli? And then I will say something, I will add something. Rewrite Article 50 you know more than I, but of course that was one of the articles that more reforms or projects of reform or amendments were proposed, 46 amendments. It was very difficult. There were states of all sides, those which didn't want. The United Kingdom, you have the right to withdraw, that's it. It is the formula of the United Kingdom, the one that was followed. So for me, it is quite difficult to argue, on the contrary, that is not a sovereign, irrestricted right, because the intention of the United Kingdom was that. So that's why I look at the nature of the EU more than the words themselves. The intention was there. The debate was focused. Take it into account that in the process of integration, and particularly as procedures is concerned, one looks back into the history of the United States. In the US, it is not foreseen that a state can leave the federation. And precisely when a few years ago there was an attempt by Texas, another one, the Supreme Court said the founding fathers have not foreseen that they can leave the federation. Europe could have opted exactly for the same view. Think it well, because you're not going to be able to withdraw. And at the beginning, things were like that. There was not a clause allowing to withdraw from the union. But in these questions, of course, one can go to realpolitik and go to the facts. If someone is not at ease in this situation, let's see what happens if I want to leave. But it could have happened. A lot is being said now about reform of the treaties and the need to reform them. And there are lists or indicators of the points that would be good to reform. Some point to Article 50, because it is a complex article, and of course it is possible that it might be put into question its very existence, but that should be adopted by unanimity of those remaining anyway. But we will see what happens. I saw a hand over there. Congratulations, and keep at it, because you are taking a risk when you are working on an open issue like this one. I have to make a disclaimer. I'm not a Brexiter. With the explanation I'm going to give, perhaps you think the opposite, but I'm not a Brexiter. I would like that the United Kingdom leaves if the conclusions of the Council, the European Council of the 16th February were adopted. In that case, I wouldn't like them to stay inside. But I believe a lot in the European Union, and I live from the European Union, but I've been studying public international law for many years, and that was my first training. And of course, I have to say that Article 26 of the Vienna Convention cannot be understood or read without Article 62 of the Vienna Convention. The Pacta Sunt Servanda entails the rebus sic stans. This is an international treaty, whereas the US is not a treaty, an international treaty. If the treaty has been done among sovereigns, Pacta Sunt Servanda is the golden rule. But if circumstances change, we might fail to comply Pacta Sunt Servanda. Will of the Parliament, British Parliament, which represents the British people, leads us to think that circumstances have changed. In that case, they could stop belonging to the European Union and complying with the treaty. If Article 50 did not exist in the Treaty of the Union, the Vienna Convention would be applied, and it would be even worse, because it would be withdrawal without procedure. Here, at least, there is a procedure, a hard one, which we should have to think whether the European Union law is a public order where Pacta Sunt Servanda doesn't work, but a set of principles and values that should be assumed at any rate. But please do not forget Article 62 if you use Article 26? Thank you. Yes, you answer, and then we give the floor to another one. I'm going to reply first. Otherwise, I'm going to forget it. Very interesting, your question, and very relevant. Thank you very much, coming from a professor of international law. Indeed, the first part of my PhD dissertation analyzes the right of withdrawal before Article 50. And one of the arguments related to rebus stantibus, which I found it in the doctrine, is that it wouldn't be accepted, its application to the treaties of the European Union, or parts of the doctrine does not believe so, because treaties have their own mechanisms for interpretation and reform. Of course, first they could resort to reform. A great deal of doctrine believes that it is not applicable because it is also a treaty which finds ways in which a state can confront those changes. And it is also quite controversial that a change of domestic policy justifies the withdrawal from an international treaty. I don't know whether this has a specific name, but usually it is quite difficult to justify for domestic changes in the country that it is not bound to fulfill the treaties. It should have to be a civil war or something. It is very strictly interpreted, too strictly to be applied to the treaties of the European Union. But it is obviously an opinion that some people believe that Britain had the right to withdraw. You have to take into account also that Article 50 was introduced first in what was going to be the European Constitution. So we are located in a legal norm of legal status. When the Constitution as such, with that symbolism, was left aside, the Lisbon Treaty reproduces it, but a debate was not made. Has the nature of all these things changed? Because it is not a formal constitution, and it is a treaty with constitutional functions, because the Treaty of Lisbon has constitutional functions. A debate would be sparked there to see whether the nature of the norm had to be taken into account when you go from a constitution to the Treaty of Lisbon. Now you have the floor.
Your presentation, I found it brilliant and ambitious, the fact that you go for an interpretation of. And I have a question. I do think that that your interpretation of Article 50 as not unilateral, not unconditional, so it's sort of restricted. It's the right interpretation. And I would like to ask you something. In the last plenary of the European Parliament, before the UK was about to decide whether to leave or not, to find a deal or not, they voted for a series of provisional resolution to determine a series of issues. For example, what's about the status of the EU citizens in the UK, whether they're not going to find a deal with the EU, what's about the trade between the UK and the European Union. So to a certain extent, the European Union was acting unilaterally to prevent that the no deal would have affected negatively, for at least for a short period in the aftermath. So I do not have a legal background, but the question to you is, what's the base on which the European Union could act unilaterally to, I mean, what was the base of the European Parliament to act unilaterally and say, okay, we are going to find our provisional agreement for in the case of no deal?
It's a good question. I think the basic difference is that if you act unilaterally in order to protect or give rights, then there shouldn't be too much of a problem, whereas to act unilaterally to withdraw rights from the EU citizens is more controversial in international law. You see the difference? So the Parliament was acting to protect and...
Yeah, no, my question is, let's imagine that there was no deal. The
Yeah.
European Parliament has voted on a provisional agreement. And let's imagine that the UK does not recognize this provisional agreement because they want to withdraw. I mean, is it a feasible or possible situation in which the UK does not recognize a vote of the European Parliament because they leave unilaterally the
Yeah.
European Union? So they say, okay, now we do not respect. In that case, who is going to judge whether the UK is allowed not to respect the provisional agreement of the European Parliament, the European Court of Justice, or the UK itself?
But if the UK didn't sign the deal, it's not binding on it.
It's not at all?
No, it's the Parliament can decide to, like, if it's a deal of providing rights to UK citizens, for example, that's like something that the member states are obliged by, and they have to grant us residence, and then you can do that unilaterally. But the UK wouldn't recognize it, no. Is there anything?
Muchísimas gracias para una presentación.
Thank you very much for a very clear presentation. For a non-legal person like me, and thank you to the professor for giving us the context. A non-legal question, and the professor mentioned the case of Ireland. Could a limitation be built to the right of withdrawal on the basis that this is risking the peace? Because the European Union has been defending the principle that the border does not exist between the two Irelands. And that has been also the opinion of the British negotiator. But couldn't it be a limit to that? It is also a good question. We go back to what is compulsory to be included in that withdrawal agreement and what can be included and what not. I see it from the EU perspective, and that would be related to international law, whether there are international responsibilities derived from establishing those borders. Yes, but treaties oblige to respect inner borders of the Union, and that is an added problem there. And that is why the border between the two islands is so problematic. Yes, but we have the Good Friday Agreement that there is the danger of being violated. It should have to be renegotiated. It's also an international treaty which cannot be taken lightly. So they are obliged by that. The issue of Ireland is very complex, and apart from thinking of Scotland, etc., there are millions of reasons, but the key issue of why they haven't been able to withdraw, the Irish border is one of the most important questions. We have the IRA violence looming around and so on.
This kind of complexity, and you did very well.
Thank you.
In Italy, we say that explaining complex thing is never easy, and indeed was actually brilliant. And I think you also are involved in that because of your background and so forth. So it's nice studying with love. It's important. Well, my question is trying to reverse the point of Article 50, and as I'm not a jurist, I would like to ask both to you and the professor your opinion on the value of a popular referendum in Europe. Because before Brexit, 1 year before, there was the referendum in Greece for accepting or not the bailout pact or agreement.
And then they ignored
and
the
the
result.
The Greek people, they said no.
And
It was 61% of the votes saying no. And exactly 6 months later, both the government and the European institution, they actually completely ignored the will of the Greek citizens. While today we have another referendum, and is it possible that there is not a common recognized value for this kind of popular consultation in Europe? So sometimes both the national and supranational institution can say, I basically don't care. And in other case, yes, I do care so much that many years we are still debating on that. So that's not just a political opinion that I'm asking to both of you, but also from the point of view of the legal standards of our integration. Thank you.
It's a very good question. We also talked at breakfast about the referendums and this direct power of the people. It's very controversial. I think Brexit is also a vaccine against referendums, definitely. So referendums generally, when they're authorized by Parliament, you have to have a vote enabled to activate the mechanism, and it will stipulate legally what the results, what the government will do with those results. And even in the constitutions, it already, some of them, because Britain doesn't have a constitution and it isn't big on referendums, I think it's only the second or third it's had in its history. They will state if it is binding or non-binding, the result. Normally they're non-binding, so it's just popular consultation. They're just going to ask what you, but it doesn't mean I'm going to do what you tell me. You know. So if you tell me to do what I want to do, then I'm reinforced. My mandate is stronger because the people are behind me. If you tell me to not take the European Union bailout, and they're going to throw you out of the Eurozone, I mean, then probably you're not going to listen to them. I think it's a very, very difficult question when it is, normally it's non-binding, but the British Brexit referendum was non-binding. But it is very, very difficult to go back once you've asked. And I think that shows also the difference of strength of democracy. Britain is finding very, very difficult to not respect this referendum result. It's really painful politically. But I think they've realized that, they didn't think they were going to lose. They thought, the government campaigned in favor of remaining. Now it's very easy to say, well, of course they're the most Eurosceptic population in Europe and you've been bashing the European Union for 40 years. Of course they're going to vote to leave, but nobody really expected it was that bad. But I think referendums will change because of Brexit, maybe. They will, for example, sometimes they require more than a simple majority to make it more democratic, because we also talked about this is very slim majority. Difficult question.
Sí, en Reino Unido el principio de la soberanía parlamentaria hace que el referéndum.
The United Kingdom, the principle of the sovereignty in Parliament means that it is not binding, the result of a referendum, because the sovereignty resides in the Parliament. The debate in Britain was that the referendum did not adjust from the Venice committee to which the UK is part. The requisites of the committee were not met when special and very important elements related to sovereignty were in question. So that wasn't done. And so the standard that should have been fulfilled was perhaps not met. Another referendum could take place if the government is authorized by the Parliament. Let us recall that there were two cases in the European Union when two states, one of them did not want to join the Maastricht Treaty and the other one to the Treaty of Lisbon, Denmark and Ireland, respectively, where after rejection in the first referendum, there were left 2 years of reflection and a second referendum was convened. So it would be possible to use the same methodology that has also precedents in the UK, but that should be the UK to decide whether to organize a second referendum or not. I have the mic. Congratulations for your presentation, which has been brilliant, and simply to suggest just a new line of work. You have spoken of Article 50 as a precedent, thinking of other states that might want to withdraw. President of the United Kingdom withdrawing from other European institutions, because that would limit its sovereignty as well, belonging to the Council of Europe and other institutions. So if they want to take back control, they will be under control of other European institutions as well. So perhaps it should be thought whether withdrawal from the Council of Europe, which is less supranational than the European Union, is there a similar Article 50 in the statute, which I don't recall, or it is simply the Vienna Convention? Just a suggestion to give it another thought. Since it is a suggestion, we will give the last person the floor because we have very little time.
Well, Polly, I will just speak in English since you spoke in English.
Thank you.
The presentation was terrific. And from a legal perspective, I found it so interesting because regarding Brexit, everybody has an opinion, most of the time political opinion, but we forget about law. So my question or my reflection to you is whether you are assessing the loyal cooperation, because I think during this process, the UK has not been very loyal since they have been negotiating trade agreements behind the European Union. So I think that they're preparing for a Brexit, negotiating trade agreement. So that's my question to you, whether you think that the principle is being respected that they should respect it because they are still members of the European Union. So that's basically a question. Thanks a lot.
That's a very good question. Also, it's very relevant. It's the principle of local cooperation related to Brexit is always mentioned also as a obstacle for the UK to negotiate future trade agreements while it is still in the UK. It's very interesting, but the principle of local cooperation works both ways. So the EU kind of has to understand that this state can't leave with an absolute, with its deal with the EU, but what happens with the hundreds of treaties that the EU has, which the UK belongs to and will no longer, I think it's also part of the EU's responsibility to not forbid. So what it is doing is in fact talks, but it can't sign anything. But it's sort of preparing its way in order to have a framework in place, and I think that is part also of the EU respecting the UK's wish to leave, and that it also has to allow it to have a legal framework in place.
Okay, muchas gracias, Polly.
Many thanks, Polly, for your work. Thank you all. We are right on time. This is the last moment, and thank you very much for participating here and for the interest you have shown and for the questions you have asked and the observations you've made. Thank you.